All right, folks, welcome to the December 16th, 2022 edition of the Employer Handbook Zoom Office Happy Hour. What are we calling this one? Essential Employee Handbook Updates for 2023. But you know us, we couldn't just stick with that. We'll talk a little bit about the year in review and a lot of the changes that will inform the handbook updates for 2023. I've already talked to everyone about closed caption. That is turned on. I should remind folks that we are recording this. I did remember to hit the record button. So if you're watching this on YouTube, hey, you're not going to get the chance to ask questions live, which people can do using the chat feature. No one should be able to turn on their video or unmute themselves. But if you have questions live, use the chat. If you're watching this on YouTube, I hope you enjoy our back and forth, our content. And if you really like it, subscribe, like, do all the things, comment. Other than that, let's get to our guests. We have a fresh face here on the Employer Handbook Zoom Office Happy Hour, and that is my partner, Christina Bost Seaton from up in New York City. Christina, how you doing?
Hi, it's nice to be on here.
Yeah, tell everyone about yourself.
I am a management side employment lawyer here in New York. I'm also a business litigator. I would say the majority of my practice is in the space where the two fields meet. So I do a lot of work advising on restrictive covenants and drafting restrictive covenants, as well as litigating on those issues. And I just have to thank you for this opportunity, because my daughter is going to be so excited that I'm going to be on YouTube.
Yeah, when I told my kids that this channel has more followers than some YouTube channel in one of their classmates runs, they were like blown away. Blown away. Subscribers, excuse me, not followers, subscribers. Amy, good to see you again. What's going on?
Not much. How are you?
I'm living the dream as always. Why don't you tell everyone what's going on in your life?
Really?
Sure.
No. I'm Amy Epstein Gluck. I am blessed to be law partners with Eric and Christina. Like Christina, I work in the intersection of business litigation and employment law. I would say I lean more toward the employment counseling and advising than the litigation. I've been doing a ton of business litigation lately. I have been revising handbooks all month long to prepare for 2023. I primarily represent employers and help them solve as many of their problems as they bring to me.
That sounds good.
Yeah.
All right, folks, before we get started, put it up in the chat. What states do you want us to pay the most attention to today while alienating everyone else who is attending this Zoom? Here we go. This is the perfect time to give the disclaimer. Here's
I love
the disclaimer. We're lawyers, but we're not giving legal advice today, right? And we're not creating any sort of attorney-client privilege. And as I look at all of these states, California, Iowa, Massachusetts, none of us are licensed to practice in those states. So what we're going to aim to do today is, while we may focus here and there on some state-specific issues, we'll try and keep it brief so we don't get tomatoes tossed at us by, the other people who don't operate in those states. But we're going to try and offer some pretty general advice, trends we're seeing, and issues you should be thinking about, especially if you're a multi-state employer, that could spawn some changes to your handbook for 2023. And ultimately, take the non-legal advice we're giving you and go to your employment lawyer, pay them to assist you with updating your handbook for 2023, okay? Don't take your advice from a Zoom or on YouTube, all right? Cool? All right, let's get started. So first, I said, what are some of the changes? What informs what is going to happen with your handbook in 2023? So there were some big changes in the law in 2022, and Gretchen Carlson is responsible for two of them. Isn't that right, Amy Epstein Gluck?
Who is?
Gretchen Carlson from Fox News. She's responsible for
yes,
ending forced arbitration of sexual harassment claims and the Speak Up Act. Sorry, I was a little too cryptic there.
Not a problem. I just didn't hear what you said.
That's
Yes.
okay.
The biggest news, I would say, for the second half of 2022 is the Speak Up Act, which renders unenforceable NDAs and non-disparagement provisions about sexual harassment and sexual assault allegations entered into before disputes arise. So all of those templates that are floating around within your company that you may or may not be having your lawyer look at, they're gonna have to be changed. You're gonna want to change them right away. And the idea is really to follow up on the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, which is not silencing victims of sexual assault and sexual harassment with an NDA. And we first saw that in 2017, 16, when Gretchen Carlson exposed Roger Ailes on Fox News. That's why Eric is making an allusion to that.
Yeah. So yeah, she has been a champion of getting both the Ending Forced Arbitration Act and the Speak Up Act
Yes.
passed.
Yes,
If-
it's
Go ahead, Christina.
Amy, go ahead. No,
Oh.
Amy, go ahead.
I was just gonna say, it's not retroactive. It doesn't take effect until after December 7th of 2022. And there are exceptions to this. So definitely, you definitely want to connect with your employment lawyer to discuss.
I was just going to add on the litigation front, there was just an article, I think this morning in the Washington Post or perhaps the NPR, I'm not sure, but basically they're anticipating that there's going to be a lot of defamation lawsuits that are brought as a result of this. There's a very high profile one that's being brought right now by one of the women who testified before Congress as part of getting this act passed. So that is something that your companies could be dragged into as well. And it's something that you should think about when you're dealing with these issues.
Wow. And to be clear, these aren't necessarily things that you would add into an employee handbook. In fact, I wouldn't put this in an employee handbook. This is more for your standalone agreements, your onboarding agreements, be clear, employment agreements with your non-at-will employees, kind of your higher level executives, someone who's signing something more than an offer letter, where you might try to slip in some anti-defamation language or confidentiality language. You're going to need a specific carve out for these laws, at least for the Speak Up Act. And then obviously you won't be able to, your arbitration agreements, you won't be able to arbitrate the by default, the sexual assault and sexual harassment claims. One other big thing that happened this year, well, they're big things, but one of the big ones, and I'll touch upon it real quickly, was at the Department of Labor. And this was with joint employer. So the definition of, we were talking about what was, what would constitute joint employer. There was also changes on employee versus independent contractor, how you're going to treat them. We've kind of devolved back into a totality of the circumstances test. It used to be, at least under the prior Department of Labor regime, it was more emphasis placed on control and the ability for profit and loss. And now there is there are 6 factors, all of which basically are, equal to one another. So we go back to the way it was. Not necessarily something that you're going to get granular on in an employee handbook, but something to keep in mind as you onboard people in 2023 and hand them the right agreement, whether it's, they're truly an independent contractor or they are an employee. Sorry, I slipped away from joint employer. And I mixed my agencies. I apologize. That was National Labor Relations Board. But Amy, did you want to talk about, we'll get a little state specific about what's going on down in District of Columbia, Maryland, Virginia?
Yes,
employer?
Sure. We call that the DMV. And that's right where I'm located. DC, Maryland, and Virginia, it's a little more complicated here because the statutes in each state have completely different definitions of employer. So, a lot of offices are, in Virginia and DC, or DC and Maryland, or Virginia and Maryland. And they're really going to need to watch what the feds are doing, because what's likely going to happen, if I had to predict, which as we know, I cannot, the state courts are probably going to rely on the changes to federal law. So just be aware, be on the lookout. That's such a hot button for litigation when a plaintiff's lawyer is trying to allege a violation of the FMLA or the FLSA and bring in a deeper pocket.
For the National Labor Relations Board, there has been a flurry of decisions really within the past month, and also the general counsel at the National Labor Relations Board has been quite aggressive about trying to basically shift the pendulum back to the way things operated under the Obama National Labor Relations Board. As you folks know, when you go from a Democrat president to a Republican president and the complexion of the National Labor Relations Board changes, we go from a more employee-friendly environment to a more employer-friendly environment. And now we're seeing that shift back as it's a Biden presidency, and we have 3 Democrats on the National Labor Relations Board. So the big takeaway here, I don't want to get too granular, we'll talk about this more as we go through our presentation, is that for your handbook, anything that you have in your handbook, whether it's surveillance, or electronic monitoring of employees, social media policies, confidentiality language, things like that, that could tend to have the effect of chilling employees from talking about working conditions with one another. The board is not going to like that. And that holds true whether you are in a unionized workplace or a non-union workplace. We saw this many years ago in a lot of non-union workplaces with social media policies, where people, they felt as if people weren't allowed to say what they want, talk together on whatever social media platform or in the workplace about working conditions. So just be mindful of that. And also keep in mind that even if you have one of those disclaimers in there that says, this policy is not intended to infringe upon employees' Section 7 rights, that's probably not going to be good. So again, that's what we want to highlight with the National Labor Relations Board. Christina, you wanted to talk about the Respect for Marriage Act, which just passed, and how that could impact.
Yes. So despite the Okerfeld Supreme Court decision that happened several years back and the recognition of same-sex marriages and also interracial marriages underneath that had originally been banned underneath Loving versus Virginia, those laws still remained on the books. The Defense of Marriage Act still remained on the books. The Respect for Marriage Act that was just signed officially took the Defense of Marriage Act off the books, and is clear that if it doesn't make states give marriage licenses to same-sex couples or to interracial couples, but it does say that if a state has granted a license, the federal government will recognize that license and that marriage in every other state. Really, I think that's just indicative of a trend we're seeing nationwide of increased specific legislation protecting the rights of protected classes and not relying strictly upon common law and administrative interpretations.
Right. And for your purposes, I know we have a lot of HR people on the line. Check your benefits and check your policies and make sure your benefits are aligning with the law.
And if you're in a religious organization, well, there's probably going to be a lawsuit at some point. So these rules don't necessarily, they're intended to apply across the board, but we realize, the non-legal advice we're giving today is for what we interpret or construe to be the majority of our audience. And we understand that some folks may work for religious organizations that may have issues with same-sex benefits. So in that regard, your mileage may vary. But for most folks, the Respect for Marriage Act will require a thorough review of benefits to make sure that you are in compliance. I guess we'll have to talk about, oh, I don't think that's a very controversial issue, but we'll do the one controversial issue now. And that is Dobbs and Roe v. Wade and how that may impact employers for 2023. Amy, you want to talk about that a little bit?
Sure. I mean, as I'm sure you know, and everybody on this call, Dobbs v. Jackson in June of this year overturned Roe v. Wade. And while we may think, how does that impact employment? It actually really does. And as I'm sure you've seen, there's been a lot of litigation in the country in the last 6 months about benefits, about whether employers can provide benefits to their employees to take leave to cross state lines or not. And I said it at the time, and I'll repeat it now. A lot of the answers to these questions, there's no bright line rule. A lot will depend on where your employee works. An employee who works in Chicago is there's going to be a completely different response than an employee who works in Texas, right? So where the employee works, which we know from our handbooks, right? Because our handbooks, all the leave provisions pertain to where employees work. So that is really the issue that you have to consider. And I'm sure by now you've had conversations with your teams about benefits and whether you're going to provide them or not. So as the law continues to develop, it's worth it to have those conversations, determine what's lawful in your state, and see about the benefits you want to provide. We'll remind you that, federal law still prohibits employment actions. Still prohibits sex discrimination, right? So you want to be aware of the laws that still exist, and in places like New York, California, I believe Illinois, but don't quote me on that. It's a reproductive health decisions are protected classes. So there's more to keep in mind when we're talking about abortion and the right or not right, and the legality of abortion than the Supreme Court decision.
And I would just also please consult your benefits attorneys, because that's the ERISA, it's a special benefits law, and there are special requirements that those be applied evenly to all employees as well. So while the likely determination and litigation would vary wildly depending on the location of your employee, what you're allowed to do still has this federal layer over it that has to be considered.
Exactly.
I see on our outline, Christina, a lot of New York and New York City changes. And I see from the audience that there is a pretty strong request for some New York guidance. So with apologies to the rest of you who don't operate in New York, could you give us a Cliff's Notes version, Christina, of some of the big changes that New York and New York City employers need to focus on?
Yeah, this is going to be a very big picture. There's a lot of litigation that's happened. These are generally legislation that's happened. I want to point out these are typically and generally, these are not going to be things that necessarily affect your handbook. These are more things to keep in mind from an HR and counseling perspective. So first of all, New York State has enhanced its whistleblower protections. So we are more in line now with some of the federal whistleblowing standards. There is a form that's going to be promulgated that's available on the New York DLL website, and employers will be required to post a notice informing employees about their whistleblowing protections. We were sort of an outlier that our state whistleblowing act was really focused on public sector employees, and now it applies to all employees. And then there's a special healthcare sector whistleblowing law as well, that if you work in that space, you know how much an issue fraud is. So to go talk to your healthcare attorneys for advice in that space. The New York State Human Rights Law has issued a special anti-retaliation provision that it's a little sui generis to me. I'm not familiar with seeing this in other states, but I'd be happy to hear from people who have. It prohibits the release of a employee personnel file by an employer and retaliation for the employee exercising their rights to oppose discriminatory practices. So I actually have not had the time to research what situation happened that made them think they needed to pass this law, but this to me feels like there's a story that led to this, and I'm interested in finding out more about it when it comes up. I've never dealt with that in all my years of practice being an issue, and I would certainly never, and I think all of us on this call would never advise you to just release an employee's confidential information in their personnel file willy-nilly as part of your efforts. There is a new New York law that was just passed that says that you cannot punish employees for taking absences that they're allowed to take underneath the various paid leave laws. And essentially that's made to deal with employers that still have a no-fault point system in place with regards to keeping track of absences.
And that's something that would apply. That's something, again, we're not 50 state experts, but if your state has earned sick leave or paid sick leave, I'm guessing more likely than not that in the statute, it says something that you can't retaliate against someone for taking leave that is covered by the statute. Sorry to interrupt, Christina.
No, does it yet? I think these little cleanup bits of legislation will occur because reason would stand that you should not be punished for taking leave that you are entitled to underneath the law.
Well, and for all practical purposes and from a litigation standpoint, that's just adding a statutory claim that plaintiffs' lawyers can bring against companies for discrimination or harassment and retaliation.
Correct.
With increased penalties, so don't do it.
So New York State has also increased their protection for nursing mothers, and effectively what they've done is they've taken the New York City code that was enacted several years ago and brought it up to the state level. So these are all best practices that we would have been recommending to you already. So it should be a location that's not a restroom. It should be a location that has adequate lighting. It can't be a closet with no light. You should have a chair. You should have an outlet for the woman to plug in her pump. It should be close to running water so the equipment can be cleaned. And there's also a requirement that if your organization has a refrigerator that's available to employees to use for their lunches, for example, you also have to allow nursing parents to be able to store their breast milk in that refrigerator. Practically speaking, what a lot of companies will do is just buy a special refrigerator, like those tiny little mini fridges, just for purposes of that room.
And this is absolutely handbook worthy for anyone in any state because of the Fair Labor Standards Act rules on pumping and breastfeeding and making sure that non-exempt employees have the time or given sufficient break time to do it. You can put into your handbook whether it's paid or not. Some employers will give it as paid time anyway. Also, you want to make clear in your handbook if you haven't done so already. And I realize some of this is a little bit dated. Most of you have it in your handbook, but with COVID, everything was a blur and maybe you haven't gotten around to it. Just making sure that no one ever has to pump in a bathroom. It should be a private space with a locking door, and it's good to spell all that stuff out. Sorry, Christina.
No, I agree with you completely. New York State has also enacted a sex harassment helpline. So if people believe that they potentially are the victim of sex harassment at work, they can call this helpline and get advice as to what their next steps might be. And the sort of interesting thing about that is that this phone number needs to be now included in an employer's postings and policies for sex harassment. Also, this just happened. It's called the New York Adult Survivors Act, and it temporarily has lifted the statute of limitations on sexual abuse and sex harassment claims. So essentially, it's giving a 1-year window for anybody who has a previously barred claim to bring that claim. And what I find very significant about this is you might think that this statute was directed purely for criminal aspects and for sexual assault situations. It's not limited to criminal cases. It also applies to civil sex harassment cases. And there's already been a flood of litigation happening in corporate settings where there are viewed to be deep pockets. So there's a flood of cases against Wall Street And there's also a flood of cases that are being brought against New York media companies who are accused of having permitted an environment of sex harassment to have existed for decades.
Back in the 90s when the bro culture was at its finest. Yep.
Correct.
Wow.
So that is something to really pay attention to. And it is not at all unlikely that some of your companies may get claims underneath that, and then you can consult litigators. And lastly, New York has passed an employee privacy statute that's similar to those in many other states. Essentially, that again just codifies what we've already told you is best practice. If you are monitoring your employees, you should tell them that in advance. And now if you don't, you're not going to be able to engage in that.
Right.
All right.
With specific language. No, with specific language that you want to put in the handbook. That I think we were doing mid-year, as well as that hotlines number and the information about personnel files. We also have I know I'm skipping a little bit, the Pay Transparency Act in New York, which joins its friend in California. And I want to say Washington State, but I'm not 100% on that. Where employers now have to, especially as HR, when you are setting out those written job descriptions, you need to put a salary range, not 0 to 2 million, like some New York companies were doing, but a real salary range. And that the purpose of that is to at least decrease the pay inequity issues that apparently we're seeing. So it's just something to be aware of. And that includes all written descriptions, even those like on LinkedIn. So yes, thank you. It is Washington. So just something to be aware of. California too has a million new laws and required notices that haven't even come out yet. New bereavement laws, new definitions, but I know we'll get to all of that.
I just want to point out very quickly also, New York City's Department of Consumer Protection had a law on automated hiring tools that was not,
Right.
It was going to require any company that uses an AI-based screen for their employment practices to basically not use any such software unless it had gone under an anti-bias audit within the last year. That law passed. It is now suspended until April because of a flood of public comments, because the requirement was not necessarily something that was capable of being certified. So that's, one of the laws you see sometimes that are with the best intentions, but are not, thought about in the best way in terms of execution. On the radar, municipality wise, we have legislation that is, has been proposed to eliminate, at-will employment in New York City. I don't think any of us believe that that's likely to get passed, but it's certainly worth noting in a group like this. More likely to pass are some of these legislations that are both at the state and city level to promote and protect certain industries of people where they're known to have the worst employment practices and the most vulnerable employees. So we continually see bills being introduced with regards to tipped employees and their protections, to the independent contractors who do deliveries and trying to bring them into the employment space, and hospitality and the way that scheduling is done in those fields. Those laws are appearing all across the country in different municipalities and states. So if you work in those sectors, you should talk to somebody to see if those are coming down the pipeline.
Thank you. I'm going to skip a section in our outline. I think we have some time at the end. We're going to talk about kind of some other considerations or things that may be on the horizon for 2023 that could impact handbook edits either now or if you're really proactive or later in the year. But I want to get to some edits that we're looking to make. Amy, things like DEI, employee wellness, and mental health. How are you seeing that translate into employee handbooks for 2023?
One thing that I've seen and I've been doing in the last year, especially with DEI, is use of the word they instead of he or she. herself or himself. It may not be grammatically perfect, and believe me, I was an English major, so it does hurt me. But it is much more inclusive. I think DEI wise, after the events of this year, with some very high profile public figures, we're seeing more language in handbooks about anti-Semitism included in protected classes. Anti-Semitism could be under race, religion, national origin, any of it. But we're seeing more LGBTQIA protection, more anti-Semitism protection, and since 2020, more of a racial focus. To that extent, and as I think we've talked about before on this channel, employee wellness and mental health remains a huge issue. And it really was a star player in 2022 with employers beefing up their employment assistance plans or EAPs. So if you can provide mental health benefits, get with your benefits counselors, because mental health issues are skyrocketing. Anxiety, depression, bipolar, PTSD, suicide. There was a terrible suicide this week that was well publicized as well. We're seeing so much, and EAPs are so great, right? You can often talk to a therapist at low or no cost, depending on what your benefits will provide. So I think that we're certainly seeing a lot of that, and I would encourage HR to really focus on that as well, because you have your business folks who are very profit and performance oriented, and then your employees who may be miserable, and there's a way for the two to meet, right? And I know you all are in the intersection. I was just going to say, to the point of the person who just sent a note in the chat, you want to train your managers. Consider putting examples in your handbooks about recognizing invisible disabilities. Because if you have a workforce with more than 15 employees, or you're in a state with the Human Rights Act, you're going to be subject to disability laws. Maryland, I'm not part of Maryland, but I'm working for Maryland, just expanded their disabilities laws. A lot of states have. You want your managers to understand what they should be looking for when somebody has an invisible disability. They may not feel comfortable going to HR, but if their performance tanks, if they're acting, completely out of character, if they can't seem to focus, if they're late all the time in a very short period and it's out of character, you want to connect with them and teach your managers how to do that. So we're talking about a lot of those things, as well as remote work. And Eric, you can stop me at any time, because really I could talk myself about this entire thing for an hour.
Yeah. Oh, we lost Christina. Hold on one second.
Yeah, I got a phone call. Bring me back, please.
I'm gonna let you start your video. No one else start. There you go, Christina. Go ahead.
Oh, thank you. I was just going to say briefly on that. I also think that's going to be a big field of discrimination lawsuits as well, for not protecting your employees' mental health. We just saw a major one that was brought against Yale University for not protecting its students' mental health.
Yeah.
And the same theories in that could easily be used by plaintiff lawyers to bring cases against employers as well.
It's something to look at. It's something to look for. And you know how you give examples of sexual harassment in your handbooks, because you're not required to, but you're encouraged to do so. I would give examples, of accommodation requests and what it could look like, or at least training. Because we're seeing that not just with mental health, we're seeing that with long haul COVID. Millions of people are dealing with symptoms from long haul COVID, and it needs to be accommodated.
Yeah, and I like what Amy, what you said about putting the examples in the handbook, especially with the invisible disabilities. Bear with me 1 second as go ahead, try now, Christina, turning your video. There we go.
Yay!
And hey, she's back.
I'm sorry. A client called and it just messed everything up.
It's okay, because the reality is these are the types of claims that get brought, and if we can deal with these beforehand and encourage people to seek out accommodations and deal with those proactively and provide the accommodations, It would avoid, well, it would, Amy and Christina and I would make less money from it, but that's okay. We don't need to defend those lawsuits all the time. And with respect to your mental health benefits, I would just outline them, just mention like, here's a benefit that we have. You don't have to go into great detail. And for more information, see so-and-so in HR. And we can
and repeat it, you know, definitely repeat it. Something that we instituted at our firm, and I mention the EAP all the time, is, and this was mentioned to me by somebody else in the HR space, was considering having like a group to let employees talk about mental health. And that is all part of DE&I, right? That is, whether you're in a big company or a small company, as we know, everybody's dealing with something. And that's a good time to remind people that they have EAPs. But again, you want to talk to your benefits counselor about that. Make sure your EAPs align with ERISA.
We've got about 24 minutes left. I want to be respectful of everyone's time here because I know people have stuff to wrap up in December and on a Friday, but I threw our information up in the chat so you can connect with us. If for some reason we don't get to your non-legal questions today. A couple of other additions to handbook policies. To the extent that you don't have a hybrid or remote work policy and you have an expansion of hybrid or remote work, maybe this wasn't the case pre-COVID, but now, you know, with COVID and post-COVID, you're having more people working remotely. That has to be in your handbook. Who will be allowed to work remotely, right? What are the rules for meetings? You know, like, does the camera have to be turned on? What a dress code's going to be like? And along those lines, I'm getting a little bit ahead of my skis with many states passing versions of the Crown Act, right? You want to be careful about hairstyle discrimination. So not that anyone on this call would discriminate against anyone on a Zoom call based on their hairstyle, but it could potentially be an issue with appearance and dress. So I just want to flag that as an issue. What are working hours, schedules, and accessibility going to be like if you're going to work remotely? And wage and hour considerations there, maybe a bit too granular for an employee handbook, but the big takeaway there is tracking time and making sure that if employees are going to work overtime, they need supervisor permission beforehand. If that's what you want, that's what a lot of companies generally do. Sometimes that's hard to manage when people are working remotely, but it's good to have, as Amy said, it's okay to repeat yourself a little bit in your handbook. We don't want to get them out to 75 pages, but a little bit of repetition is okay to hammer home some important points. Also, the equipment that gets used. Is it going to be company equipment? Is it going to be, can I use my own laptop and connect it to the company network? What happens in that situation? What am I allowed to download onto the laptop? What happens if I lose the laptop? What happens if I leave the company, right? Do I have to return the iPad that the company gave me? Does it get wiped? What happens? Am I responsible for theft or damage? All that kind of stuff should be addressed in some way, shape, or form in your employee handbook. Hopefully it's there already, but this is more just kind of a reminder if you've morphed into hybrid and remote work. Christina, I see you nodding. You got something to add.
Please talk to an information security lawyer when you're drafting those particular provisions, because they really have to be specifically written to be technologically correct as to how you're going to wipe and control those devices.
Yeah, that's right. Amy, you had a wonderful blog post recently on dating policies. And as we shift away some workplaces from hybrid and remote, and people are coming back to the workplace, what do you think about dating policies in employee handbooks? Should we be bringing them back? What's going on?
Well, I think I'm going to give you the employment lawyer answer of it depends.
Okay.
It depends on your culture, right? Culture is such a determinative force. And I did a lot of research when writing this article, actually, because I didn't know. I would assume that there were less issues with workplace romances during COVID. And guess what? They increased. SHRM did a survey in 2022 reporting that they increased, maybe because people, were home and there was just there were less ways to get caught. I don't know. But the statistics that I put in this blog were pretty surprising to me. Like, a third of people surveyed reported having been involved in or were involved in workplace romances. 50% admitted to a crush at work. That's a lot. So do you need a policy? I mean, I don't know. I think generally people are going to do what they're going to do, and you can't always micromanage human behavior. From a legal standpoint, you could potentially have liability if you're in a state that has off-duty conduct laws like New York does and California does and such. And that is an issue. I mean, I love a policy, right? And I think maybe a short policy, if I had to make a recommendation to my friends, which all 162 of you are, because we didn't create a legal relationship, I would say a short policy is not a bad idea. Maybe talking about when a subordinate reports to a supervisor or somebody who is above the subordinate. Like when you have a direct reporting line and a sexual or romantic relationship, you're potentially creating liability there if the relationship doesn't make it all the way. If it goes bad, we teach, and when we're doing sexual anti-harassment training, we teach, you can date someone and then be sexually harassed at work, right? If you keep asking somebody out and they say no, that can be harassment, depending on how extensive it is and what state you're in. So I would at least talk about whether you want to prohibit it or move people around. You want to talk to your lawyer about considering what to do with that. I've written love contracts.
Yeah, there's a question about love contracts.
I know, I see it. I've written love contracts. And honestly, they say exactly what I just said a policy would say. I've done them where they say, we acknowledge we're in a personal relationship and that it's voluntary and that it won't affect work, that type of thing. And if this changes, I'll let HR know or something like that. I don't know how enforceable they would be.
It's gotta be an awkward conversation.
It's such an
Are we
awkward
ready to go to HR yet?
We saw it on what was it? The morning show. If any of you all watched the morning show when Yankoff and his lady love walked into HR, he wanted to disclose and the other employee was like, no, and the office, thank you. And we're seeing it, we saw with this situation on GMA3 with Amy Robach and what's his name? I forgot his name. But, the issue there, you're not going to suspend somebody at every turn, but the issue there was they were becoming the news. So that's kind of an issue when that's your job. So we are seeing increased renewed interest in that, but much more focus on paid sick leave benefits and paid family leave benefits as an increasing number of states enact those laws, since there's no federal law providing for national paid sick leave, or increasing contributions, whether it's funded by the employer or by the state.
Yeah. A couple of other ones along those lines, benefits, parental caregiver leave, right?
Yep.
So on the one hand, that's an attractive selling point to people who want to come to work for your company, right? That hey, give caregiver, not just parental leave, but caregiver leave. Wow, that's that allows me to maintain a good work-life balance. In practice, I mean, in the actual execution, you want to make sure that you're treating people equally and there's not any sort of discrimination, whether it's male, female, or you name it. But that's a policy, not necessarily from a legal point, but just from a kind of from a attracting new employees point that you may want to add to your employee handbook.
Exactly.
I'm sorry.
I just said exactly.
Religious accommodations. I'm still surprised at the number of handbooks that I review that I get from, hey, it's been a while since we've had our handbook updated. Eric, we used to use so-and-so, or I got this online. Can you update it? I just don't see anything in there about religious accommodations. I see disability. Sometimes I see pregnancy, but sometimes I don't see religion. Make sure that's in your handbook, right? I'm not going to get into the nuts and bolts of what is undue hardship and all that kind of stuff, but just acknowledging that religious accommodations are available to your employees, unless there's undue hardship, as long as it's reasonable. And in some states, like I wrote about it this week, the Commonwealth of Pennsylvania, not a state, Commonwealth, is going to have a new definition of religious creed. So I don't want to take this down a rabbit hole that I don't want to go down, but basically you don't have to subscribe to a particular religion to have a sincerely held belief, right? So I can have beliefs that are sincerely held that just are my own, I don't want to say my own religion, but just not a generally accepted religion that could require an accommodation. That's the point I'm inarticulately trying to make.
Do you think that came out of COVID? What we were seeing.
I wasn't going to go there.
What we were seeing in COVID was, sincerely held religious beliefs to vaccine exceptions were based on sincerely held beliefs, not necessarily organized religion.
We are seeing a lot of those. We are seeing a lot of those lawsuits now. That my sincerely held beliefs were not accommodated reasonably, and we can do that on a different Zoom for sure. But since you brought up COVID-19, Amy, I do think it's important, if you have one of those old FFCRA policies sitting in your handbook somewhere, get rid of it. Yes. Get rid of it. That thing sunset a while ago. If you have paid leave policies relating to COVID, you can have that if you want. No one says you can't have it. But if you don't want it, take it out unless there is a local law that would require paid COVID sick leave. Like, for example, City of Brotherly Love, Philadelphia, home of the 12-1 Philadelphia Eagles. They have it. It's going to run through the end of 2023, I think. Is it 20?
Same with California.
Yeah. So your mileage may vary, but check that. And also vaccinations. And I'll just do you really care? Is it really that necessary that everyone be vaxxed to come in the workplace? That's a business by business decision. Just keeping in mind the enforcement issues, and someone who got vaxxed back in early 2021 who hasn't gotten all their boosters, what does that matter? So just flagging that. If that still sits in your handbook, it's worth re-examining whether you're going to require or recommend or not have anything at all about vaccinations. Christina, what else should we do in our handbooks?
So I would just remind people, you want to be double checking. The minimum wage in some of the states you operate may have changed, either in some counties, all counties, statewide, certain industries. In New York, we have an incredibly wildly complicated wage schedule. So it depends by county and by industry. But just double check your minimum wages within the states. The other thing I would point out is part of this sort of, at least in New York and some states like that, desire to regulate all the things. As Amy mentioned earlier, there is a movement to change the definition of employee in some places. So some of these statutes that I've mentioned with regards to New York do apply, either change the definition of employer for purposes of that statute to include independent contractors, or specifically mention on their face that they cover independent contractors. So just don't assume that the things you heard today don't apply to independent contractors, especially in states that are more excited about regulating the employment relationship.
Right.
Amy, we talked a little bit about some of the newer protected classes that, to the extent they're not in your handbook, should be called out specifically it's better practice than any other protected class protected by law. What are you seeing in terms of whether at the state or federal level, some of the protected classes that should be now enumerated in handbooks?
Well, you really hit it first, and I think that so many states now have enacted some version of a Crown Act
Mhm.
that I think that really, whether you do a main handbook and state law appendices, or just, take the most employee-friendly state where you have employees and use that, I would put that in parentheses for everywhere. That race is including but not limited to natural hairstyles like braids, dreadlocks, twists, etc. I think that supports your overall DEI initiative. And I just think it makes good sense for the majority of states.
Yeah.
You're going to hit it there. I would keep in mind the LGBTQ inclusion, especially after this recent statute. So much more with domestic violence. We're
Crime
seeing
victims too, yeah.
crime victims, domestic violence victims, people with criminal backgrounds. We're seeing in so many more states. I mentioned, and I'll say it again, there's so much more with bereavement leave. I've been kind of surprised, whether paid or unpaid. Some states now have paid bereavement leave.
California, I believe.
It does. It does. It
I
does.
stayed in the Holiday Inn Express last night.
There you go. There you go. As well as increase leaves in the states for domestic abuse and crime victim. I mean, I could talk about this all day. A lot of
Some people could probably stay here all day.
I know there's still so much with vacation payout. I have to say that again, and it came up for me twice this week with two different clients. If you're in California, your vacation, are considered wages. But if you are multi-state, or if you're in another state and you don't want to pay out vacation at termination, you have to say that in your handbook. Okay, you're going to have to say it's not a cash benefit if you provide vacation, and it's not going to be paid out at termination for any reason, if that's what you want,
Yeah. Massachusetts has pretty persnickety laws on that, if I
Yep.
remember correctly. And I remember reading Maine just passed one on
Yep.
vacation payout. So
Maybe Illinois as well. I'm not sure as well.
yeah.
But it's something, Illinois is a pain. Illinois has a lot of new laws. My multi-state employer clients, it's been a bear with all the different laws that have come out. Absolutely.
Let's also flag just marijuana as more states legalize for recreational use marijuana. You want to check, or have your outside employment counsel check the law to see kind of what your ability now is to drug test. Do you need reasonable suspicion? Can you still do it randomly? What happens with the results? For example, I know there are a bunch of people on here from New Jersey. We're still 40% in limbo as to how to deal with how to deal with drug testing current employees. I've been given some guidance, but there's still some gaps left to fill. So you want to be mindful, especially if you're a multi-state employer, right? How marijuana, cannabis use can factor into employment decisions. You want to articulate that in your handbook.
Absolutely.
I want to throw this out go ahead, Christina.
No, I was just thinking, sort of pre-employment marijuana testing and screening. The other sort of thing that is relatively new underneath New York City is credit discrimination. I know way back when it used to be routine that people would go ahead and screen for credit worthiness of applicants before employment. You can't do that in New York City. You can't discriminate on the basis of their credit. That's been since about 2015 here, but I wouldn't be surprised if that's something that rolls out to other states as well. You have to really sort of evaluate all that packet of pre-employment paperwork.
I'll throw this out to both of you. How do we deal with the expansion of remote work literally people working in, we have a company that's based in, I'll pick on Pennsylvania, Commonwealth of Pennsylvania, but they have people who work full-time remotely in 5 states outside of the Commonwealth of Pennsylvania. For your handbook, how do you treat that? You go appendices? Do you put it right in the main handbook? What's the move?
I mean, it depends.
And
It really
right.
does. It depends. I have clients who want the appendices. I like an appendix. I have clients who, have separate if I would say if you have employees in California and New York, like that's going to be troubling not to separate it out in some way. But it depends on what your culture is. It depends on what your situation is. Do you run a risk of somebody thinking they're not getting the benefits that other people do? Yeah. Yes, I would, communicate, communicate with your employees. I would be clear if you do that about why you're doing it. For California employees, for Virginia employees, if you're talking about your mythical employer in Pennsylvania, for New York employees only, for New Jersey employees only, because New Jersey is like becoming the California of the East very quickly, following New York City with all the paid leave. So for me, I like to be overt about it.
Yeah. Someone asked, what about separate supplements for remote workers in those states? I mean, I suppose that is,
Yeah, that's what I'm talking about.
A little pamphlet. Yeah,
Yeah.
that is possible. That is possible.
I like that.
We are getting close to the top of the hour. I'll go
But
to.
I do want to say one thing about that. If
Go
you
ahead.
do appendices, you want to reference that those policies are meant to go with the ones in the main handbook. It's not one or the other.
Correct.
So you want to make sure that they're read together.
Right. And I suppose an alternative would be you just do a most favored nations type handbook where you take the most generous policy from any of the states and you just give it to everyone.
I have to say, though, I think that's more challenging now that we're on the other side of COVID, because you have so many state funded leave laws, and like Massachusetts just came out with this entire contribution rate system, and New Jersey has one, and New York, and so many of the states, Oregon, right? How do you give the most liberal states laws to people who are not in that state when their payroll tax isn't coming from that state? I think that gets complicated.
Well,
Yeah.
there's a question I'll ask Christina. Have you encountered situations in which employees have to report any moves across states or municipalities? So fully remote. We're not talking about commuters, but fully remote.
I have big theories about that. I think employees should always be required to update their actual mailing address for lots of reasons, including if your employee disappears and you're worried about their welfare, you need to know where to go and find the employee. But yes, I mean, because the company has an obligation to pay taxes, for example, in the states in which the employee operates, the company really needs to know where the employees are located. And I think the importance of that has to be messaged better to employees, because it's an ongoing, there's sort of a belief that employees are going to, they're going to get in trouble when they tell this, or I don't want people to know that I'm doing this, and I don't want my employer involved in my life. It's not that the employer's not trying to surveil you. They just need to comply with these certain aspects of the law. And I think that's really sort of, it's really a failure to communicate the importance as well as it could be. And that's something that we all need to work on a little bit.
Right. I mean, that's a whole separate webinar on its own, which I think I did earlier this year, on the tax implications and the compliance issues and local employment laws and the implications when you have that.
Well, since we are hitting the top of the hour, I want to give each of you a chance to say your closing piece, if at all, while I add our contact information to the chat and thank everyone for coming out. So Amy, thanks for being here. What do you have to tell our folks? Where can they find you? What's new? What's going on? What do you want to say?
Thanks for having me. This is so great. What do I want to say? I want to say, check your handbooks, make sure they're updated. For 2023, I see a lot of handbooks from 2017 and 18 and such, and that's gives me a heart attack and keeps me awake at night. And make sure that your handbook really matches your company and where you are and how you operate. You can find me on LinkedIn, and I know Eric just put that in, or on the firm bio at fisherbroyles.com. Shoot me an email, call me. I'm always here.
Yeah,
Christina, we don't bite. We were okay, right? First time here?
no, it's actually really fun. Thank you for having me.
Cool.
I mean, my big picture here is if something feels funny to you and you're worried about it, you should have a trusted advisor that you call. You shouldn't be working these things out on your own. Definitely have some lawyer who you're willing to call and ask these questions. They need to be asked. It's very important.
Awesome. Good advice. Good non-legal advice. It's as close as it gets to legal advice, but being safe. All right, folks. Thank you so much for coming out today. This is going to be the last one of the year. I think, do we do an impromptu one later? I think realistically, this is the last one of the year, but we have some great ones lined up for January. I don't want to give away any hints just yet, but trust me, they're good. Yeah, people ask, is this being recorded? Yes, it's being recorded. Not only is it being recorded, but when I post it to YouTube, I put in little chapters. So you can fast forward to the parts that you like. You don't have to sit through the whole thing. Well, when did Christina talk about New York City law? We'll put that up there. So you can skip around. Otherwise, I hope you enjoy the rest of your day and happy holidays. We'll just keep it at that to everyone, so I don't have to rattle through the list.
Happy New Year.
What's that? And Happy New Year. Yeah.
Happy
Happy New Year. Thanks for having me, Eric. This was
You're
great.
welcome. Wishing everyone prosperity and good health, and we'll see you again in 2023. How about that? Bye, everyone. Thank you.
Have a great weekend.